From News Channel 8, this is News Talk with Bruce DePoy.
And we are so grateful you're with us today. Hi, everybody. Welcome. We've got a great lineup today. Thanks for spending part of your day with us. Jury selection is underway in the trial of a Baltimore police officer charged in the death of Freddie Gray. Officer William Porter expected to be the first of 6 officers to stand trial. Potential jurors are being screened in private in chambers by the judge. Voir dire being done individually with attorneys and the defendant present, but not the public or the news media. Glen Ivy served 2 terms as Prince George's County's top prosecutor. He was state's attorney. He's now an attorney in private practice, and he's a candidate for the House seat being vacated by Senate hopeful Donna Edwards. Welcome back. It is good to have you here.
Thanks for having me.
So much going on. Let's talk about the situation in Baltimore, where a police officer will soon be on trial. They're in the jury selection phase now.
Right.
Officers who have been charged by the local state's attorney, the post you once held, the comparable post in Prince George's, these officers are going trial. These officers are standing trial individually as opposed to in a group. Can you walk us through why, in some cases, defendants, whoever they are, police officers, regular people, what have you, sometimes they're tried as a group where they're all there at the table with their attorneys, and other times it unfolds the way we're seeing in Baltimore. One, then the next, and then the next, etc.
Yeah, usually there's a motion that's filed by the defense in advance of the trial, as was the case here, where they ask the judge it's called severance, to split them up into separate trials. Defendants usually prefer to be tried separately, and especially in this scenario, if you're going to go last, or you're the 4th or 5th or 6th to go on trial, it gives you a chance to look at the prosecution's case, look at their witnesses, and adjust your defense accordingly. Usually they aren't granted, but they were granted here.
What determines how the thing unfolds, and how does it impact the proceedings as they take place?
Well, I mean, one of the reasons prosecutors like to have defendants joined together for trial is because if somebody's going to blame someone else, they're both sitting there at the same table pointing the finger at each other, as opposed to if you have a severed trial, they're pointing at an empty chair. And so it makes it easier, I think prosecutors tend to believe, to get convictions when they're sitting there as a group. It also makes it easier to get convictions against the individuals that have the weakest evidence against them, because then you want to prosecutors will try and say that they were sort of all in it together and they were all part of the same thing. So it's a little bit of guilt by association is what is the concern for a defense counsel.
In a case like this where they're being tried separately, who makes the determination as to which defendant goes first? And do you infer something about how the prosecution is going to try to win convictions in these cases by the fact that this officer Porter is first up?
Well, I mean, my understanding is that the prosecutors hope that he's convicted, and then they can use some of the statements that he made against other officers subsequently. Frequently, prosecutors also want to lead with either the strongest or one of their stronger cases, because you want to get off to a strong start and get a conviction. It also might lead to other defendants down the road pleading guilty. The defense approach, on the other hand, I think is going to be to wait and see. Those who aren't on trial right now will want to see what happens in this case. If this is an acquittal, I think it makes it more likely that they're going to either hold out for a trial or demand some sort of a plea that is very, very favorable to them.
Doesn't it seem likely that there is going to be this blame? I mean, there's the scenario, I guess, where Freddie Gray died of accidental causes or in a manner that the police had nothing to do with. But if there was police wrongdoing, there was wrongdoing by one or more officers, we're going to see over weeks, months, however this whole process takes, Officer A blames officers C and E. B blames A and D, right? I mean, no one's going to admit to wrongdoing. They're all going to blame the other guy or the other guys or women.
You can see variations. You could see them blaming other people. For example, if you're not the driver, you might say, look, I wasn't driving the van. I didn't give him a hard ride. I didn't have anything to do with that. You could also argue, and I think you're going to find this with all 6 of these, you know, we didn't do anything that violated police procedures, and we didn't intend to individually to hurt this individual or cause his death. So I think you'll see all of those defenses. So, you know, the prosecution's going to argue that there was intent, that they did fail to put him in a seatbelt to hold him down, and that led to his death, and that they did it intentionally.
When the judge, I hope I get this right, when the judge asked the room, is everyone here aware that Freddie Gray died in the back of a police van? Is anyone unaware of that? No one raised their hand. When the judge said, is anyone unaware that the city of Baltimore has settled with the Gray family? No one raised their hand. In other words, everyone is aware of all of it.
Yeah.
This was a crisis for the city of Baltimore. It's universally known some aspects of what happened. How does this impact the absolutely crucial process of seating a jury that can put aside whatever the people think they know and base their decision in the end only on what happens in the room, in terms of evidence? Right.
I mean, in most criminal cases, none of the jurors or prospective jurors have heard about the particular case or know any facts about it, so it makes it easier to pick a jury. However, you do have cases, and high-profile cases like this one. I had several of these when I was state's attorney in Prince George's. People have heard about it, so the next place the judge goes is, have you formed an opinion about it? Can you listen to the evidence and be fair? Can you make your decision as to whether there's guilt or innocence based only on the evidence and the law as I instruct you? And so that's how they'll try and sift it out. But, of course, the defense moved for a change of venue before the trial got started for this reason. They were saying everybody knew about it and is going to be unduly influenced by it. I think one of the challenges on that front, though, was that even if you'd moved it to another county in the state, everybody there knew about it, too. So the better argument they'll have, though, is the issue about the riots and sort of a pressure on the jurors to come out with a conviction. And I think that'll be, if there's convictions here, I think there'll be an appeal that challenges that.
In the pre-internet era, when information didn't flow so quickly and to such a broad extent, the change of venue seemed like a real option. If something happened in your county and it was inflammatory and there were concerns about seating a good jury, you could go to Charles. Does that seem like an old-fashioned or quaint notion now, when people in Charles know as much about the people in Landover because of the internet, the web, the fluidness, if you will, of information?
Yeah, I think it really does undermine the value of a change of venue, even if you shift from one media market to another. So if you went from the area where Baltimore TV stations are viewed, to an area where Washington, D.C. TV stations are viewed, you'd still be getting a lot of spillover with respect to that information. And at some level, even in the old days, for example, when George Wallace was shot in the state of Maryland in Laurel, the courts ruled that a change of venue didn't matter there, in part because they thought he could get a fair trial, but also because everybody had heard about it. And so you weren't going to get away from jurors knowing about it anyway.
There's already been significant civil disturbance in Baltimore. If I'm on the jury and I don't think this officer did it, or that the prosecution proved their case by a reasonable doubt, which will be the standard here, that this officer did it or the next, something happened, but I'm just not seeing it, I'm not feeling it. Am I going to have the courage of my beliefs, knowing that there's already been unrest? It's not a hypothetical. How do you weigh the pressure on jurors to do what the community wants, even if it's not there, in your view, in terms of what was presented?
Jurors have tough jobs, and it's not simply in this kind of a case. There are other variations of this, too. Say it's a heinous murder, and a lot of times jurors are going to feel pressure to convict. Someone's dead. You want to hold someone accountable. And so the job of the defense is to argue, no matter how you feel about it or how you think other folks outside this courtroom might feel about it, your job is just to follow the law and the evidence. But it's a real concern, and I think they're trying to feel it out in the voir dire process as well.
How do they decide which judge gets a case like this? Is it like a random thing where it's a case, a judge, and it's off a list? Or does the chief judge, the scheduler, look for someone with experience in a certain area, or they bring in a retired judge, or it's someone with maximum gravitas, or someone who's done trials with big media attention and community interest in the past. That's a factor at some level, isn't it?
Yeah, it can be all of the above. I think in this instance, I mean, usually they assign cases randomly within some constraints. You know, any judge on the criminal docket could get a case, but I think he was specifically selected in part because of his experience as a prosecutor handling these kind of police excessive force cases.
Talking with former Prince George's prosecutor Glen Ivy. We will take a quick break here. We are, though, back with more right after this. Keep it here.